quick game. Yeah, it was.
And push record on your camera. Okay, and then you can just hang out in there until I come to relieve you.
Yeah, I'll just let you take over as necessary.
Yeah.
So thank you, brave souls, for coming to this little talk about the Oyez Project and the plans we envision for its future. We've reached some real milestones, and I wanted to share that with you today. And I'm assuming some of you are Supreme Court junkies. Anybody here a Supreme Court junkie? Okay, great. So did you read the Myriad decision this morning? Well, if you want to, you can grab it on our mobile apps, and we'll be talking about them today, this morning. And Josh Clark's comments have resonate with us because we've been through this process, and I think there's some important lessons that I've learned, myths debunked this morning, that we will probably add to our stack of things we have to do. But today I want to talk about making no small plans. Now that you're in Chicago, some of you were from Chicago, I know that. How many of you are not? Great. So this is the source of that great thought. The great architect Daniel Burnham, who's responsible for the city plan of Chicago. He was the grand designer for the World's Exposition in 1894. And that's what he said. He said, make no little plans, they have no magic to stir men's blood, and probably will not be realized. And that I think is an accurate characterization of what I started some years ago when I saw this article in the New York Times. It appeared April 3rd, 1979, on the op-ed page by Yale law professor Robert Coburn. And he did this thing called the Law Baseball Quiz, comparing baseball players to justices. And the idea stuck with me. And it stuck with me because I thought the baseball card would be a reasonably good metaphor and mechanism for conveying information about the Supreme Court to the audience that I was trying to reach at the time, which were undergraduates, because I was on the faculty at that point as a political scientist at Northwestern University. I should add, we are the Oyez Project. So I'm Jerry Goldman, this is Matt Gruhn. Matt's the tech lead and was my student at Northwestern. So he's been through this drill and understands my craziness. So the baseball card became a metaphor for me. And I thought, okay, well, that's an old-fashioned baseball card, but could I make it look like that? All right, well, that was the thought I had back in, way back in the day, probably, I think it was 1988 in Wrigley Field. In the bleachers, Cubs were losing, and I thought, gee, I felt inspired that maybe there's a way to use this idea of baseball to convey information about the Supreme Court. So here's a team image. Could we make it into a team image? Yeah, well, the technology back in that day enabled me to do this. So, does anybody remember HyperCard? This was the environment in which I thought, man, I could do some really cool stuff. So I created something called the Hitchhiker's Guide to the Supreme Court, and it had 3 components. There was information about justices, information about cases, and a tour of the Supreme Court building. For those of you who are familiar with the Oyez Project today, those same components really drive the project and provide navigation to its contents. So this is, again, it was all bitmap graphics, and this was my crazy idea of how to find information about justices, so you could specify a date and then see an array to account for the different number of justices. So back in 1862, you could count and say, you know, how many were there? Well, there were 6 instead of 9. Of course, someone asked me, well, did Taney really have his office back there? Well, this building didn't go up until 1935 or so. So, you know, it was, I was mixing images in the wrong way, but it was still fun to say, okay, I could specify this date. Does anyone know what happened on 5/23/54? Brown versus Board of Education. So those were the justices who decided that case. When you tap on a justice, you get, this is the baseball card idea, get an image of the justice, some information about the order of appointment, seat, so forth, years of service, some data. Flip the card, well, that's another card, this is Harry Blackman. You flip to the back of the card, and you get some little bio sketch, some prior experience. You know, he played in the minor leagues. Where did he play? What teams did he play on? So that was my craziness, along with a way to navigate through the content. The Justice card also listed all the cases in which this justice authored an opinion, and then you'd have information about that opinion. So you get facts, question, conclusion, and vote, and then figured out, hey, you could actually add audio. There was audio. I discovered that there was just piles and piles of audio kept in the National Archives. You had to sign a contract with the archives declaring that you would not distribute the information except for educational purposes, but I thought I was on safe ground. And then you had some voting information. Again, it's the same structure, the same basic content that's in the Oyez Project today, but in a much more engaging environment. And again, the court gave me permission to take some videos of the aspects of the building, including the conference room, which was pretty cool to see. Yeah, there it is, and this is just an image of the conference room, and then we embedded a little video, which was truly about as big as your thumbnail. But that was HyperCard. So that was then. Now let's turn to today. And I'm going to assume that you know what the Oyez Project is and what it does. I wanted to just share some hidden information about how to use it, and then talk about our grand plan for the future. So one thing you can do from our collection of audio is to create a clip. And you can do that from the website. If you just mouse down over the extended player view. In the extended player, this is Bush versus Gore, and this is what you might get.
We'll hear argument now number 00949, George W. Bush and Richard Cheney versus Albert Gore et al. Before we begin the arguments, the court wishes to commend all of the parties to this case on their exemplary briefing under very trying circumstances. We greatly appreciate it. Mr. Olson.
Mr. Chief Justice, thank you. May it please the court. Just 1 week ago, this court vacated the Florida Supreme Court's November 21 revision of Florida's election code, which had changed statutory deadlines, severely limited the discretion of the state's chief election officer, changed the meaning of words such as shall and may into shall not and may not, and authorized extensive, standardless, and unequal manual ballot recounts in selected Florida counties.
So when you mouse down, you can invoke the clip and share function, highlight a segment as much as you wish, and then you can select, having selected that, you have the opportunity to save a clip for embedding purposes. And then have that functionality. You can also download the clip as an MP3, have that on your desktop, and repurpose it as you wish. And what you get is...
Chief Justice, thank you. May it please the court. Just 1 week ago,
exactly
this court
what you
vacated the Florida
heard
Supreme
and
Court's
highlighted
November
in the
21
previous example.
revision of Florida's election code, which had changed.
Now you can also do the same thing in either of the two apps that we developed. And this is where I think we'll switch over to an app display and demonstrate what we can do. The two apps, I should have gotten to the next two slides. The first one we developed is called Pocket Justice, which is the corpus of constitutional law, about 650 cases decided by the Supreme Court from 1790 to this term. And those cases include about 300 hours of audio. That one has a price tag associated with it. It'll cost you 99 cents. The second app is SCOTUS Now, which is a collaboration with our Institute on the Supreme Court of the United States here at Chicago, Kent, and it is only the cases on the current and previous Supreme Court docket. But it's every case. If it's admiralty, original jurisdiction, con law, you name it, if the court has granted certiorari and decided the case, that content will be on SCOTUS Now, including all of the oral arguments and opinion announcements when those materials are available to us. They've been transcribed and they're accessible, as we'll demonstrate with the app. So let me demonstrate, the price of that one, that's going to cost you because it's free. It'll cost you the time that it'll take to download it and use it, but it's a free application. Pocket Justice, the Con Law app, has been supported by the continuing generosity of Justia, Tim Stanley, and fellow Justians have made it possible for us to bring these materials to the public. So let's take a look at Pocket Justice. So here's a listing alphabetical of all the cases. You can see that there are quite a few, but let's try reverse chron order so we get the most recent ones. Come back up here, and we should have, yeah, okay, so we're at the 2013 term, and I've identified 4 cases so far that that the court's decided, that the court has on its docket. It just decided today the Myriad case, though it wasn't a con law case, so it's not in this collection. But let's turn to, well, actually we have, this must be by, not chronological, this is by calendar year, not by term. So let's try Fisher versus Texas. The court hasn't decided that one yet. So you'll see, again, same basic structure and content that we have on the Oyez Project. So you have a fact section, a short question posed in plain English we think the court has addressed, some information about advocates, and the important part here that I want to show you is the media. So,
well, I get to say that this is case number 11345, Fisher against the University of Texas at Austin. Then you get to say.
This Mr. General Souter trained me too well. Mr. Chief Justice and members of the court.
So you get the same content that you have on the expanded player, but you get it in a different format, and relying on gesturing components, you can just flip through it or search for a particular term or phrase. And
her claim is not necessarily that she would have been admitted, but that she was denied a fair chance in the...
So it's easy enough, and frankly much easier, to work your way through the content of an oral argument on a mobile device, and in my judgment it is on the website. But what about functionality here? Well, let's see. Let me move through here and find a chunk that I thought was really interesting. Okay, here's Scalia.
Seriously suggest that. Why don't you seriously suggest that,
So I just held my finger down over the segment and I created a clip. Similar to the highlighting and mouse down function from the website. Take that clip. Notice that at the bottom of the screen, I have some opportunities to do something with this content, and the one that I want to invoke is the share function, clip and share. So I'm going to send this to Matt.
Still can't spell my name.
Yep, I gotta get, it's typing. Tapping. So now I can send him the clip, which contains not just the little MP3 component, but it also contains the section of the transcript associated with that segment. It's also possible from the, let's go back to the original. If we wanted to select an entire turn, let's say Bert Rhine's turn, we'd select all the segments to the turn, and then we can create a clip of that entire turn. You can also collect non-contiguous segments and share those as well. So there's a lot of functionality that we built into the app, and in some ways it resonates with Josh Clark's talk this morning on the matters you need to contemplate when you're building an app. And though we haven't touched on all of them, I think we hit a few nails on the head when we came up with this component. I think we can switch back now to. All right.
Think about it for a minute.
Yeah. All right, there we go. So we're back to. So pocket justice is the con law corpus, only constitutional law. If you want everything on the current docket, it's SCOTUS now. Pocket justice is 99 cents. Helps support the Oyez Project, and SCOTUS now is entirely free, but focused solely on the current term and the previous term of the Supreme Court. So we demonstrated the app function, and I thought Matt, being my tech lead, could tell you something about how it's done.
Okay, so I'm going to geek out here for a minute since I'm the geek in the team. So as Jerry has alluded to, sort of the principal holding of Oyez is this vast collection of Supreme Court oral argument audio. And recently we have essentially completed that collection with a few holes here and there, but we have collected all the oral argument audio available going back to 1955 when the Supreme Court started reporting in the court. So we really want to make this content available and accessible to the public, especially in light of the fact that really only a select group of people ever really get in to see oral arguments of the court. If you've never done that before, it's quite an experience. It's really amazing walking in and seeing this vestige of this grand theater of law. We wanted to make that available to the public, and it is publicly available through the National Archives. And now that we have all that content available on Oyez, our next step is to try to think about how we can make it more useful, more accessible to people. One of the ways we've done that, one of the ways that's actually turned out rather nicely, is through the use of HLS to deliver that content to apps. So you saw when Jerry played the audio on the app, it had a little pop-up. I don't know, we went through kind of quickly. I don't know if you saw it, but it asked if you wanted to stream or download the audio. If you select stream, what it's doing is using HTTP live streaming, which is what HLS stands for, to deliver that content in really small little segments to the app. HTTP live streaming is a method developed by Apple. It basically takes an audio file, or it works with a video file too, carves it up into numerous little tiny segments and delivers it piece by piece to the app. What that enables you to do is the moment you open that app, there's no download delay. You can just scroll through and find the segment you want to play from there. It's a nice little user experience tool because it's always irritating when you get that little buffering delay while you're watching the video or something like that. This sort of makes that go away. So that's what we've done on the app front.
So back in the day, you remember Ripnick's Burn, and now that that's gone, we think it ought to be replaced with Swipe, Tap, Share. That's the virtue of what we've created with this user experience. So one of the challenges we have is to capture data from this user experience.
Right. So I should mention the player you saw earlier that's currently on the website is Flash-based. It uses the old Flash streaming protocol, which is the predecessor to HLS. We're currently redeveloping that and building an HTML5 player that will use HLS to deliver data. But one of the other features we're building into the new HTML5 player that will work equally well on your desktop or your mobile device is we've got all these sort of user interactions. You can clip a segment, you can search for a segment, you can play a segment, you can share it on Facebook or Twitter if you're really nerdy. That's all valuable metadata, right? It says something about this segment that you could just clip. It's interesting to you for some reason. I don't know why it's interesting, but it's interesting. One of the things we're doing in the new HTML5 player is we're sort of preserving the fact that someone, we're not quite as creepy as the NSA, but we're preserving the fact that someone created a clip of this particular segment of the audio file. So there's something interesting going on here. Now you aggregate that data over everyone that interacts with the player, and you can sort of imagine using that data to find the key segments that are really interesting within this vast collection of audio, sort of unlocking the black box of an audio file, right? So we've sort of been doing this in sort of a quasi-informal way with the way the player works today. And what we found looking at the log data, the impetus behind this, looking at some of the log data, seeing what people were taking segments of, was really interesting. So last term, I was looking at the log data of what people have taken clips of on Oyez using that function. The most popular segment on Oyez was Antonin Scalia talking about broccoli during the Obamacare arguments last year. So that's actually was really exciting, and to nerdy me, it was really exciting because it shows that through a purely social mechanism, without knowing anything about the content itself, you found this really important, or really interesting segment that people found really interesting. And so it shows that social approaches to unlocking the black box of audio data actually work. So we're hoping to extend that a little further with the new HTML5 player, providing more interactive functionality with the audio, capturing more of that data. I'm really excited about the prospects and the analytics that we can develop on that. In an ideal world, we'll one day have a page on Oyez that lists these are the 10 most interesting segments in all of Supreme Court oral argument history. And you can go in and say, here is this brilliant commentary from Roe versus Wade, or this brilliant question that Scalia had during Fisher versus University of Texas, something like that.
Now that's interesting for the words, the spoken words, the utterances that have been captured. And there are some interesting words and phrases that we found, but we won't unlock that. treasure for you. You can go hunt it for yourself. But there's one that won't be obvious to you. It's back in 1956. Some of the earliest audio that we only added this year to the corpus. It captures one of the justices. Well, let me step back a second. When you go to the Supreme Court as a tourist, you can see the bench. But no tourist is allowed behind the bench, ever. But I happen to know that behind the bench, at each of the justices' chairs, below the bench, are what look like waste buckets, but they're actually spittoons. But they're used as waste buckets. But we have some evidence that the spittoon was actually used as a spittoon. Back in 1956, some justice, I think we could narrow it down to 2 or 3, but I don't think we've identified the exact justice, formed a giant loogie and landed it in the spittoon. But that's just something that...
That segment will not appear on the list.
Yeah.
Of most popular segments.
All right, now I want to talk to you about the current status. Where are we now? Into the past, know something about the present, a little more about where we are right now. So we've collected all this information from October, first Monday in October 1955 to the last oral argument that the court heard this term. And on the first Monday of October this year, we will receive there on that date or shortly thereafter the opinion announcements from this term, because the court doesn't release those in anywhere approximate to the actual release of the opinions. So I'm going to do this in Johnny Carson style. So this is the great Karnak, the Magnificent, who was a skit that Carson performed for many years. So this is my rendition of the great Karnak, and I'll need your cooperation. So the answer to this, the answer here is 32. What's the question?
10 less than the answer.
It's the number of justices you can hear throughout the corpus, our audio corpus, stretching back to 1955. So there have been 32 justices who have sat and spoken in this period. Okay. Answer. 86, more than 8,600. What could possibly be the question that information answers? The number of advocates who appeared before the Supreme Court in this period. Right? Answer. More than 70%. That's an interesting answer, but sorry, it's wrong. It's the number of advocates who argued only once in the Supreme Court. Okay. Here's a list of names. Why are they ordered as they're ordered? Lawrence Wallace, Edwin Mueller, Archie Cox, Michael Dreeben.
What's the number of times they argued?
Correct. So Lawrence Wallace leads the list with 157 arguments. And going down from there, Needler, I think, turned the corner. These are both career SG appointments. And Needler turned the corner on 100 a couple of years ago. And so forth. Right? Here's the answer. A list of all the justices. What's the order?
How often they spoke.
Say again?
How often they spoke.
Correct. You get the prize.
Sean Scalia's at the top.
All right, so Scalia is at the top. Number of minutes spoken only in oral argument. And you want to look to the bottom to see who's the GOAT. Well, really not. It's Sherman Minton. Everybody remembers him. With a great opinion. We have only about 17 minutes of him speaking in oral argument. He served for several terms, but his last term on the court was 1955. So we don't have much data. But we do see above him Clarence Thomas, little less than 23 minutes total over his, what, 20 years on the Supreme Court. So, and Scalia takes the cake. Answer, 13,723. Question. The number of hours today in the Oyez corpus. We're adding more, but I don't know, it'll be a while before we turn the corner on 14,000, I would guess. Answer, 66 million plus. This is easy. The number of words transcribed from that 13,873 hours of audio. Now, a lot of work, crazy idea. Make no small plan. And we've accomplished, I have accomplished this mission, and now I'm thinking about the future. Maybe my wife should press me more to fully retire, but I can't manage to do that. So we want to create something called the Oyez Consortium. And it'd be great if we could get some help from fellow CaliCon participants. Let me explain what we want to do. We want to create Oyez projects for every state high court and for every federal appellate court. We've accomplished one, the Supreme Court. Now we just have to do all the circuits and then all the state Supreme Courts.
We've done one, so 63 to go.
Actually, we've done two, because we do have a prototype for the state of Washington. It's called the Temple of Justice. And if you want to check it out, you can. Organized a collaboration between one of our volunteer consultants, Jeff Parsons, and a group at Eastern Washington University. This is what we plan to do. If we can manage to locate the support for this, we'll provide all your technology. We will do all your app development, leveraging the work we've done for our apps to date. We'll provide all hosting services. We'll help you raise money so you can bootstrap this. And finally, we hope to provide startup grants for every consortium member. Now, what do you have to do? Members provide content. Content is king. We can scrape state web court and federal appeals websites for information, but we need to transform that information into useful data. So we need to reduce often complex legal issues to straightforward explanations in simple declarative English. And we need to transcribe the audio or video and put that in our player and containers. So timely content is really important. We want members to provide this content in a non-technical, simplified, stroke and white format. And we've got to be neutral about our politics. We may despise or dislike or praise to the heavens the judges on these courts, but best is to park those preferences to the extent that we can outside the door in creating this content. And we hope that in bootstrapping the fundraising efforts, that a small component of that would come back to support the mothership, because we're doing a lot of the heavy lifting. So that's what we need. If we get a chance to proceed with this project, we targeted 5 states for our first endeavor. Those would be the 5 largest states by population. California, Illinois, New York, Florida, and Texas. So our hope is that we'll be able to actually get there. I think.
So just to, since we've got a little extra time, I think just to explain our thinking behind the consortium, if you've ever been to a state high court website or a federal circuit court website, sometimes they're not bad. Sometimes they look like a throwback to Yahoo GeoCities in the 1990s. And that's, you know, I don't blame the courts for that. Typically, the courts don't have a lot of funding to throw up websites, and their clientele is really internally and to the lawyers who practice in those courts. The public is something of an afterthought, and it's just how it is. It's not good, it's not bad, it's just how it is. We want to try to fill a need for the public, for members of the public, for journalists, for academics, anyone looking at that data, by taking the data off those courts and whatever other data we can get our hands on related to those courts and putting it into a more useful format online, making it easily accessible for a well-structured website, providing case summaries like Jerry was talking about that are really designed for members of the general public, providing the media, oral argument, audio or video transcribed, so it's searchable, so it's easily accessible, making all that data available through an API. So that's really useful for developers. There are all kinds of political scientists, empirical political scientists who look at the data at these courts and spend an enormous amount of resources trying to make the data useful before they can actually answer any of their research questions. So trying to reformat the data into an open standard or ripping it from a PDF and things like that. We want to make it easy for them to get their hands on that data. So we really envision the consortium as sort of an online legal library almost. We're just making this data available, and we hope that people will take it, use it, do really interesting things with it. So our clientele is the public, journalists, academics, all kinds of people. So that's what that effort is really about.
Well, in getting as far as we have, and certainly for me in the last 25 years, I owe some thanks to some people who have made this journey of mine possible. Tops on the list would be Tim Stanley and Stacy Stern of Justia, Hal Varian, who I only met once at a conference many years ago and has been very supportive at a critical time when we needed to finish the archive. Jeff Parsons, my volunteer engineer, who was an early Microsoft employee and now enjoys doing public service projects like the Oyez Project. And Steve Griffin, who was program manager at NSF and now is at the University of Pittsburgh School of Information. And Mark Lieberman, a polymath, faculty member, computational linguistics at the University of Pennsylvania. These people have really enabled me to do some things that I could have only dreamt about 25 years ago, and it's been a great ride for me, and my plan is to continue doing it. Now, we're open to any and all questions, and I should have said right at the beginning, please interrupt me because that's my preferred style of communication. So, is there anything you'd like to know that we haven't covered? Any criticism, vision, plan that you'd like to add to our collection of things we need to do? Yes?
How does the transcription work? How do you transcribe the oral arguments?
I wish we could say we had a really sophisticated natural language processing algorithm that does signal processing and transcribes it for us. That would be a lie. We outsource that to some English PhD students in India who transcribe it manually. For current oral arguments, the court actually produces a transcript in real time and delivers that at the same time to make the audio available. And then we, currently it's actually manually aligned by some cheap law students who sit around listening to oral argument audio and hit spacebar every time they hear the end of a sentence to add time codes to the transcript. We're actually looking at automating that process because that is much more automatable than some kind of automatic transcription process. Right. Yeah. It's important to us to have reasonably accurate transcripts. You could probably get for some of the Supreme Court audio, which at least modern Supreme Court audio, which is not bad, you could actually probably get an okay automated transcript. It's important to us to make it fair. We have really high standards for our transcript accuracy, and that's because The transcript for us is really the key to unlocking like what I call the black box of audio. Because when you look at a media file, if you're looking for something specifically in that media file, it's impossible to find without just sitting there listening to it or jumping around trying to find the spot that you're interested in. Then transcript makes that possible, makes it possible to search it. So we have really high standards for our transcript. That's why we do it manually.
So that reminds me that one of the principal use cases that drives this next generation of the Oyez Project from Drupal 6 to Drupal 7 is the ability to search for a word or phrase, say the phrase strict scrutiny. Say, I want to identify every instance where Antonin Scalia uses the expression strict scrutiny, and I want to see the transcript and I want to hear him say it in context and return that instantly. So that's one of the virtues of having accurate transcripts. Now, transcripts, accuracy also means speaker identification. And this has been a big problem for us because prior to 2004, the transcripts did not identify the justices who were speaking. So we had to go in and add that. Some of that was done with some AI, and most of it was done with humans. And the accuracy of the humans, I think, is pretty good. But part of the problem for doing this in using an engineered solution is that the audio quality is so variable and continues to be a source of concern. The court, until 2004, recorded all its audio to reel tape. And reel-to-reel tape is a long-lasting medium and met archival standards, except that the court didn't always keep its tape recorders into specification. So sometimes the audio would be too fast across the transcript or too slow. So the voice would either be too high or too low. It would be longer in length than what we know to be the actual time that the experience does. So
but if you ever wanted to know what Antonin Scalia sounded like if he were a chipmunk, we have plenty of examples.
Yeah, that's a good example. But we had to address that. When this process was entirely manual, some assistant clerk in the marshal's office or assistant marshal failed to set the machine up properly so it didn't capture an argument. So the correction to that problem was to reduce the amount of tape that records a second of audio. The standard, archival standard, is 7.5 inches per second of audio. And there's a switch on these devices to reduce that by half. So, well, if we reduce the amount of tape that we need for an hour of audio, we can record more audio on every reel. We'll save money, and we won't lose out, except that they recorded half the amount of data. So the audio quality is half as good as it could have been.
How long did that last?
Several years.
Yeah, that was probably around the 1980s. Right?
No, it was in the 1990s.
Oh, wow.
Yeah.
I
And
mean,
then it gets worse.
I mean, when the court first started this, we had to deal with problems like the justices constantly forget to turn the mics on. So you just have this echo in the background. You're going, what the hell's he saying?
Yeah.
And you've got the problem to begin with, in that some of the older justices are difficult to understand in the first place. Byron White had an incredible amount of phlegm in his throat, so it can be really difficult to understand in the first place. Hugo Black sounded like Foghorn Leghorn, really deep Southern accent. So we have all array of audio problems we had to confront.
So now the court has come up with a turnkey solution, recording to MP3. Now, MP3 is a delivery standard. It's not a recording standard. So to generate an MP3, you throw away data to reduce the file size. Well, the only excuse for doing that is that the medium to which you're recording is expensive. But it isn't expensive. It's dirt cheap. But I can't convince the court to change from MP3 to an acceptable archive standard length.
And actually, the situation is worse at lower courts.
Yeah.
The court at least makes the audio available in an open standard like MP3. We've dealt with some of the federal circuit courts, actually a number of federal circuit courts, outsource their recording solution to a company. The most prominent one is a company based in Australia, the name of which I've forgotten. But the audio that they deliver to you, if you actually request a copy of it, is in this proprietary format that you can only play with a player that's made available by this company in Australia. You can't play it in iTunes or anything like that. You certainly can't make it available online without a link to the software right next to it, which is incredibly frustrating. These are two turnkey solutions that were probably cheap, and the court just makes them available.
I'm more skeptical. Somebody in the Administrative Office of the United States Courts who agreed to put this on a purchase order list probably got a free trip to Australia. I think it's absolutely foolish, and harms the institution.
Well, the best part about that was that this proprietary audio format that can only be played in this proprietary audio player, the software for this player only works on PC. So if you have a Mac, you just can't listen to the audio.
Well, that's just some of the frustrations we've had to deal with. But we do have almost 14,000 hours in the U.S. Supreme Court, and our plan for the state courts and for the intermediate federal appellate courts is basically to start at a point in time and move prospectively. We won't go back in time very far, limited both by time and resources. And the one guiding principle will be, well, if a case from a state Supreme Court or a federal circuit court went up to the Supreme Court and was decided by the Supreme Court, then we track that data back as far as we possibly could. So that's our grand plan, and we hope we can invite you, if you have any interest or you know somebody here who might be interested, to join us in this next stage of our enterprise. Any other questions? Yes,
Another one.
sure.
What have been the challenges of having both iPhone or iApps and Android?
It's a big challenge because the development environment, as you know, in Android is both more complex and the code base that just doesn't move from one to the other. But our developers, especially with the introduction of HLS and delivery via cellular of the audio and transcripts, it's been our biggest challenge. But we're pretty close to a solution for Android, and once we have that solution, then that'll work for both the apps and for the future of the apps for the consortium. So we're close.
Yeah, so we have an Android app for Pocket Justice out now, and it's pretty old. We haven't updated it in a while. We're redeveloping it. The fragmentation issues are really frustrating. The biggest challenge we want to deal with is the support for audio formats changes kind of frustratingly frequently. For us, it was an easy decision to start with iOS and then do Android, in part because we're both Apple fanboys. But also, when we first did the app, we were pretty early into the app game. Probably it was 2008, 2009 when we launched Pocket Justice. At the time, Android wasn't nearly as widely adopted as it is today, so it was easy for us to start with iOS. And now we're kind of playing catch up with Android. Yeah. Going forward, I think we're going to prioritize Android a little higher than we have in the past. Try to keep it on parity with what we offer in iOS.
Yeah. Our developers for the apps, we don't do that one, but we outsource that to a group in Sicily. And that's another story, another presentation. How I got to be a made man and a prince in Sicily. But we'll save that for another time. Yes?
Can you tell a little bit more about the capture data, how you do it, and also are you using that as content anywhere on the site? Is there like a top 10 list of the most popular quotes or something?
Well, not yet. The way the capture data works now is pretty rudimentary. This sort of grew up organically, and we haven't fully implemented it yet. In fact, the way we're doing the capture data now is whenever you create a clip, there's a callback, and I'm just looking at Apache log files to look at, who's creating a clip of what. So that's really basic. What we're doing with the captured data in the new HTML5 player that we're going to launch, hopefully at the start of the new term, is a little bit more sophisticated. Basically, whenever you interact with the software, whenever you interact with the software to do a search or an API call or a play from a certain point in the transcript, it interacts with our API on the server, and the server just records in the database that someone did something with this particular segment, or someone searched with this particular segment, and it actually uses sort of a scoring mechanism to figure out what's most popular. So we figure if you take, say you take a segment of audio like that from an oral argument, if you search for that segment of audio that says that you're fairly interested in that particular segment, so there's something interesting going on there. So we give that segment of audio.
Well, I get to say,
we give that segment of audio a +1 point. If you take a clip of it, that shows that there's something really interesting going on in this segment, so we give it a +2 score. If you share it on Facebook or Twitter, that shows that there's not only there's something interesting going on here, but you were so excited about it that you wanted to tell all your friends about it. So that's a +4. And over time, with enough user data, we plan to aggregate that, and it's just whatever segments have the highest score are the most, we assume are the most interesting ones. We'll see how that plays out. It's fairly untested. But at some point in the next iteration of OEA, once we've collected enough data, we will make a list available that just says, these are the most interesting segments that our users found at OEA. And we'll do some more interesting stuff with that too. It really depends on how much data we get back out of it. But it's something I'm really excited about. So to be in a year, and I'll tell you what we've got.
One of the features that's really unique to this collection are the transcripts of the opinion announcements. Now, the opinion announcements, justices will, the author of an opinion will announce an opinion from the bench. Sometimes he or she will read from the opinion, but more likely than not, that justice has prepared a separate document and has offered that as a public explanation of what has transpired in the case. Sometimes they're really detailed, and other times they're offered for the general public, for the audience that's sitting in the Supreme Court on that day. Sometimes they're as rudimentary as, in an opinion filed with the clerk today, we affirm X versus Y. But all of that information, we have done, I think, a very good job of identifying all the opinion announcements available in the trove of materials that we copied from the National Archives. The archives themselves did not do a particularly good job of accessioning the opinion announcements, but if there's an opinion announcement, we have it, we've transcribed it, and we make it available to the public. This is an example of Antonin Scalia in Arizona versus United States. This is his dissent from the bench.
I would uphold all the provisions of the Arizona law. For almost a century after the Constitution was ratified, there were no federal immigration laws.
You can also see that there are some other components to mobile application that mimic what we have on the website. So aside from media, we have information about, you have voting data and the biographical contents for the justices. You'll have, this is HTML, not a PDF, so you have more functionality out of the HTML version of the court's opinion. We are collecting location data, GIS data for every case, so we'll know where the cause of action arose, and it'd be interesting to see a map of that. My thought about this arose out of a class I taught, I don't know, back in 1982. I was teaching Osborne versus Bank of the United States, an old common law case. And they're undergraduates, they don't know diddly. So I asked some kid in the class, Mr. Smith, can you tell me something about this case? Who was Osborne? Where did this case begin? He didn't know. I said, well, it began in Chillicothe, Ohio. Another kid jumped up in the room and said, I'm from Chillicothe, Ohio. Nothing has ever happened in Chillicothe. I said, sir, you were wrong. Osborne versus Bank of the United States began there. And it dawned on me, wouldn't it be great to be able to walk down a street or you're driving across country. Hey man, there's something important happened in the Supreme Court. It happened here. So that was my great idea. One good example of this, and I think we have to figure out what to do with it, is Katz versus United States, wiretapping case, very important. A bookie was making bets from a public telephone. FBI sought to record the telephone conversation without a warrant. So it placed a device on the phone. Bookie goes, dials up, it was a dial phone, calls it. The phone location was on Wilshire Boulevard in Hollywood. Well, thankfully, thanks to Google, you have an image of that exact location. It's an exact street location. The phone isn't there anymore, but the location is important. Someone should put a plaque up there. You know, an important case started right here. There was a phone and something happened. You know, that would be valuable. But you would know that by walking down the street and saying, you know, you get a little signal. Oh, let me see. Oh, Katz versus United States. I should know something about that case. So that's the notion behind collecting all this GIS information. And then let's see, what else do we have? Other goofy ideas here. Yeah, share and print. That's all the functionality we have right now. Always welcome your ideas and thoughts and suggestions, and please tell your colleagues about Pocket Justice and especially SCOTUS now. And thanks very much.
A minute a year.
Digital extraction. Yes. I'm interested in how long
This is
there's a company called
already.
that works with Sarah. Basically, so we were there, they read the legal copy stuff for new stuff.
Oh, we're so excited.
We actually was going to do
Oh, good. Your ears must be burning.
Supreme Court audio. In fact, it's still completely manual.
That's so hard to get the structure and all that. Somebody to put it in.
So I have a partner to the National Archives, site feeds. Very low.
Yeah, I always like found that cute after.
A couple of years ago. I'm sure it does.
So now we pull copies on original, so we can create more large.
And especially because at one point,
I think he's kind of.
We use a very basic storage as that's it. It's very
Yeah, that's what I'm surprised. The guy,
yeah, the narrative document.
Yeah, I guess because I know
right, but what do you have?
We actually deliver the physical hard drive. They're all, because they record them, they started to get into this
It's hard, you know,
No, it's A starts here and then here's a couple that, right? It seems like it's so big. It's 2 days. Pizzas or whatever, and it comes back and all that. But I don't know.
So what you had in the arrow was
or sometimes we'll do a tape swap in the middle of that oral argument, so we get like a break, where it'll literally be in the middle of the oral argument. Someone will stop talking in the middle of the sentence, and then we'll pick it up like 5 minutes later.
how are gaps?
We flag them and move on. There's nothing we can do with it. He does other things. Our audio engineer does other things when we have weird instances, like he'll do volume adjustments if someone doesn't have the mic to dial. What happens is there's a mic in front of each one of the justices, and there's a mic that's always on in front of the and so we at least have a little bit of audio from like one mic if someone has to come.
Okay.
So we'll try to boost the
So
audio.
he'll be normalized.
He does weird things like that for specific instances. Or he can adjust the timing if, for example, they recorded it at high speed or something like that. Okay. So he'll do those like kinds of little
Contact
things.
people who are.
Before he
So you're not dumping waves on a.
We're actually,
Thanks so much.
we're actually in the build process right now, and if we're actually going to have those waves available to the website, but not made publicly available, so it'll only be accessible through API. So that people are interested, it's probably going to get access to it. But
I guess one last question I had for you was, has there been research interest in the transcripts to run some big,
in fact, that was one of the biggest grant we got to do this was NSA grant for the computer science program. Yeah, because they were doing computational linguistics stuff on it. So.
Yeah, what does that tell you about interaction? Does it hint at how the justices may decide? One of the big questions that we want to answer, we've got some challenge in getting support.
I didn't want to go to that example.
Being identify the emotional state of the speaker. How does that give you that added data? What does that improve your ability to predict how they will decide?
So and we have a good relationship with, you mentioned Mark.
But that's like, I don't have to do that today.
They use our audio. They actually take our transcripts and format them into a different format.